Hello, welcome to the custody page of the ULV Justice Center website. Before I begin, I would like to make it clear that the information provided on this site is not legal advice, but is provided for informational purposes only. If you're in need of legal advice, we advise you consult with an attorney. Also, if you've not done so already, please print and download the Custody Study Aid to interactively follow the video. Let us begin with how child custody is determined. The law states that judges must give custody based on what is in the best interest of the child. In making a determination of the best interest of the child, the courts must consider the health, safety, and welfare of the child. Courts also consider the wishes of a child who is mature enough to make an intelligent choice regarding custody. The law, however, does not specify an age which they feel the child is mature enough. Courts do not automatically give custody to the mother or the father, no matter what the age or sex of your child. Court cannot deny your right to custody or visitation just because you are never married to the other parent, because you or the other parent has a physical disability, religious belief, or sexual orientation. Sometimes, if giving custody to either parent would harm the child, courts give custody to someone other than the parents because it is in the best interest of the child. What is child custody? There are 4 types of custody. There is joint legal custody, joint physical custody, sole legal custody, and sole physical custody. Joint legal custody. Legal custody is the right to make major decisions about a child's welfare, health, and education. Joint legal custody means both parents have the right and responsibility to make decisions. A court can order joint legal custody without ordering joint physical custody. This means the courts may wish for both parents to have the right to make important decisions for the child, but have the child live with one parent while the other has visitation rights. Joint physical custody. Physical custody refers to where a child will live after a divorce or separation. Joint physical custody means that both parents have significant periods of physical custody. It also ensures frequent and constant contact with both parents. If a child's time is divided equally between the parents, or close to equally, the parents are sharing joint physical custody. Even in joint physical custody cases, the court may specify a particular residence as a primary caretaker. Joint custody can be terminated by the court if the court finds it is in the best interest of the child. Sole legal custody. Sole legal custody is where only one parent has the right and responsibility to make the important decisions about the health, education, and welfare of the child. Even if a parent has sole legal custody, it does not mean they will have sole physical custody. It all depends on the court's decisions based on the best interest of the child. Sole physical custody. Sole physical custody means the child lives with one parent most of the time and usually visits the other parent. Sometimes, a judge gives parent joint legal custody but not joint physical custody. This means that both parents share the responsibility for making important decisions in the child's life, but the child lives with one parent most of the time. The parent who does not have physical custody usually has visitation with the child. What are the types of visitation orders? Like child custody, there are different types of child visitation orders. Visitation is a plan for how the parents will share the time with the child. A parent who has a child less than half of the time has visitation with the child. Visitation orders are varied depending on the best interest of the child, the situation of the parent, and other factors. In general, visitation can be visitation according to a schedule, reasonable visitation, supervised visitation, or no visitation. Visitation according to a schedule. Generally, it helps the parents and child to have detailed visitation plans to prevent conflicts and confusion, so parents and courts often come up with a visitation schedule detailing the dates and times that the child will be with each parent. Visitation schedules can include holidays, special occasions like birthdays, Mother's Day, Father's Day, and other important dates for the family, and including vacations. Reasonable visitation. A reasonable visitation order does not necessarily have details as to when the child will be with each parent. Usually, these orders are open-ended and allow the parents to work it out between them. This type of visitation plan can work if parents get along very well and can be flexible and communicate well with one another. But if there are ever any disagreements or misunderstandings, this kind of open schedule can cause issues between the parents, and the child may suffer as a result. Supervised visitation. This is used when the child's safety and well-being require that visits with the other parent be supervised by you, another adult, or a professional agency. Supervised visitation is sometimes also used in cases where a child and a parent need time to become more familiar with each other. Like if a parent has not seen the child in a long time and they need to slowly get to know each other again. No visitation. This option is used when visiting with the parent, even with supervision, would be physically or emotionally harmful to the child. In these cases, it is not in the best interest of the child for the parent to have any contact. If you or your child has been abused by the other parent, please visit our domestic violence page to seek ways of protection. How can I get a custody and/or visitation order? Now that you know the different types of child custody and visitation, you may be wondering how you can obtain a child custody or visitation order. In most cases, parents can make their own agreements for custody and visitation without a court order. If you make an agreement between the two of you, the agreement becomes binding and enforceable. But if one of you does not follow the agreement, a court cannot enforce it until it becomes a court order. So before you burden yourself with court costs and attorney fees, attempt to discuss a possible custody and visitation agreement with the other parent. If that is not an option for you, the judge will send you to mediation before your court hearing to help you come to an agreement with the other parent. If you still cannot come to an agreement, the judge will settle the argument. To set up a custody visitation order for your child, you or the other parent must request an order from the court. Steps to obtain custody and/or visitation order. To request an order, you must have an open family law case. This includes divorce or separation, domestic violence, or child support. If you do not have an open case, please visit one of our family law pages to learn how to open a case. If you and the other parent are not married or domestic partners, consider opening a child support case. The most common way to ask for a court order on custody issues is Step 1. Fill out your court forms. Fill out the request for order form. You can also fill out the child custody and visitation application attachment form. It is an optional form, so you don't have to use it, but you may find it helpful in making sure you don't leave anything out of your request. It contains a lot of detail about schedules for visits and holidays, as well as other details that can help you as you try to do what is best for your child. Step 2. File your forms with the court clerk. Make at least 2 copies of all your forms. One copy will be for you, another copy will be for the child's other parent. Turn in the original copies of your forms to your court clerk. He or she will keep the original copy and return the copies to you. You will have to pay a filing fee. Step 3. Get your court date or mediation date. The clerk will probably give you a court date. You may have to meet with the mediator before the court date or go to a mediation orientation. Ask your court's clerk if you're not sure. Step 4. Serve your papers on the other parent. Have someone, not you, serve the other parent with a copy of your papers and a blank responsive declaration to your request for order form. Look at the front of Form FL300 to see if the court ordered you to serve any other documents. If item 7 in the section called Court Order on your request for order form is checked, your papers must be served in person at least 16 court days before your court date. If there are no check marks in the court order section, you could probably serve the other parent by mail. But if you serve by mail, you must do it at least 16 court days before the hearing plus 5 calendar days for mailing. If you need more help with how to serve and file your forms, please visit our How to Serve and File Forms page on the website. Step 5. File your proof of service. Have your server fill out a proof of service form. You can use of personal service and give it to you so you can file it with the court. It is very important that your server fills out the proof of service correctly. If you are allowed to and did serve the papers by mail, have your server fill out the proof of service by mail form. Step 6. Go to your mediation and court hearing. Go to your mediation before your court date if the rules in your local court require it. If you do not reach an agreement in mediation, go to your court hearing and take a copy of all your papers and your proof of service. Burden of proof. Both parents hold the burden to prove they are the best fit for their child. You must provide clear and convincing evidence you have the best interests of the child. Some things the court will consider is the home you are living in, if you are employed, your relationship with the child, and signs of abuse. What to expect after your court hearing. Once the judge makes a decision at the court hearing, the judge will sign a court order. In some courtrooms, the clerk or court staff will prepare this order for the judge's signature. In other courtrooms, it is the responsibility of the person who asked for the hearing to prepare the court order for the judge to sign. If you or the other parent has an attorney, the attorney will usually be asked to prepare this order. What if you do have to prepare the orders? If you do not have an attorney and you have to prepare this order, you will need to fill out the findings and order after hearing form and the child custody and visitation order attachment. You may also need to fill out other custody and visitation forms like FL 341A, B, C, D, or E. Each of these forms are used as attachments to Form FL 341. If there were any other orders made, such as child support, these forms have to be filled out and attached as well. For information about child support, please visit our child support page. Now that you know the steps of how to obtain a custody order, you may be wondering what mediation is. Child custody mediation gives parents a chance to resolve disagreements about a parenting plan for their child without going to court. In mediation, the parents have the help of an expert, also known as a mediator, in resolving these disagreements. If the parents are able to work on an agreement, the mediator helps the parents write a parenting plan that may then become a custody and visitation order if it is signed by a judge.